Hi folks, this is Kip from Malik. Today I'm going to be talking about a case. It's called Foulkrod versus the Industrial Commission. So the injured worker is Lynn Foulkrod. And this is a case that involves a fee dispute. And so it's kind of a unique thing. Usually we don't encounter these. And it's not really an injured worker thing as much as it's an attorney thing. So what ends up happening is this Miss Foulkrod, she ends up getting injured in 2004 where she tripped in a filing cabinet. Bunch of conditions allowed, including C6-7 protrusion. And that's 2004. So jump to April of 2015. She hires this firm S&P, and so S&P is involved with representing her from, it looks like 2015 up through I don't know, it looks like August of 21, or well, September of 2021. So that's April of 2015 to August of 2021. And in between this period of time, S&P went ahead and filed C92 increases. And so Miss Foulkrod ended up getting a number of like C92 increases, including like an 18% increase. So that's pretty good. And another one was filed, so a 5% increase. S&P was able to get her a closed period of comp that was overturned, so there was an overpayment. There was an additional condition that was filed, a disc condition at C3, C4. Looks like they might have filed that to court, and they paid the filing fee. And then they filed another increase, again, August 3rd, 2021. They got a 4% increase, and it looks like Ms. Foulkrod ended up terminating S&P September 8th, 2021, and then like a few days later, September 13th, 2021, they hired NRS. And at some point between late 2021 or 2022, Ms. Foulkrod ended up settling, her NRS settled her workers' comp claim. So what ended up S&P, I don't, they're kind of salty, because they're terminated by Ms. Foulkrod. And here's the deal: you're allowed to terminate your attorney. Okay, so if you're not crazy about how things are going, you could terminate your attorney. But the attorney might be owed money. So, and that's what this S&P was essentially filing a fee dispute and to the Industrial Commission. And what they ended up alleging, they submitted an affidavit and they had a hearing. And they alleged in their affidavit that they spent around 120 hours of work on behalf of Ms. Foulkrod at an hourly rate of $200. So they were entitled to $22,000, $658 is what they alleged. And it looks like the SHO, Industrial Commission, granted that money. And then what ended up, NRS filed an appeal to the 10th District. And then the 10th District ended up reversing the decision of the Industrial Commission. And what their basis of their reversal was, so they're relying upon revised code 4123.06 and then Ohio Administrative Code section 4121-3-24A. I'll put a link to those code sections in the description. But basically they're saying what is required in fee dispute controversies or controversy disputes is the law firm alleging they're entitled to money. They must submit an itemized statement showing all services rendered, expenses incurred, and any and all payments received. And in this case, what S&P failed to do is they failed to indicate any and all payments received. And the problem with not doing that is they may have already received monies, and if you're asking the court to grant money based upon hours spent working, particularly in a contingency fee kind of situation, we don't know what money they've already received. And the problem in workers' comp claims specifically is like this S&P filed these these PPD award things, like the permanent partial disability. Like again, she ended up getting in 2018 an 18% increase in the permanent partial disability award. So if they're the ones filing it, the firm S&P, they most likely would have taken a fee on that 18% increase. So they got paid there. On the 5% increase, they likely took a fee there, so they got paid. On the temporary total disability issue, they likely filed for comp there, and they received a fee there. So, and that's I'm assuming that's the case. It doesn't necessarily say in the case, but if they're a contingency fee type firm, which most workers' comp claimant firms are, then they would have received some type of fee. So, granting them this hourly, you know, number of hours they allegedly worked for $200 an hour, you know, the problem is they've already gotten paid, and they were paid on a contingency fee basis. So it's an interesting case for that reason. Again, we don't typically see these situations. What I think is interesting too, from a law firm perspective, is again this Foulkrod was working with this firm S&P from again 2015 to 2021, and apparently things were going okay during that time, and then just at the end in August of 2021, she gets granted this 5%, and then in September she ends up firing him, and it looks like there might have. I'm assuming there was like a communication issue between S&P and Foulkrod where they weren't explaining to her what was going on with her case, or the way that they were explaining wasn't adequate for her to help mollify the issues or the questions that she had, and then she left. And it looks like, to their detriment, she left because of that, and that's something that S&P could have potentially smoothed over. They could have fixed that deficiency, but they didn't, and so NRS got involved. And truth be told, I don't all this is all the information that I have, but it doesn't really say that, doesn't really explain, and it doesn't indicate, because it's not what this is about, but it doesn't indicate what NRS did. But we do know NRS ended up selling the case fairly shortly after they got involved with her case. S&P could have settled it, and S&P actually had a condition in court, so they would have been able to come to the settlement table, and it may have been one of those things where they weren't there yet, and then NRS gets in and they're like, oh, we'll settle it. I don't know. I would probably have a little bit. I would probably be pretty salty if I was S&P as well, but that's what happens. That's why you got to be, as an attorney. I mean, we have to communicate with our clients, and as you know, as much as is necessary to answer the client's questions, you know, based upon a reasonable amount of time. You know, you can't blow off if clients call and they want an explanation of X, Y, and Z thing. You can't blow them off. And I'm not saying that that's what the S&P did, but when clients call, workers' comp, like I always say at the end of these things, workers' comp is super complicated. But I mean, part of the reason of being an attorney is you're basically shedding light on this complicated process, and part of that is educating the client. Part of that is keeping the client up to date as to what's going on with their claim, keeping apprised of what you're doing. And here's the thing, the communication, the updates that you're going to get as an attorney to your client. Client's not always going to like the news, the information, but if you're honest, it's easier to accept that when you're, hey, this went bad, it has to appeal. We have this option or this option. And that's fine, but as long as you're straightforward, you're honest, and you're keeping them apprised and updated what's going on, that's going to mitigate or ameliorate that communication issue. And then you might not have a situation where you're representing a client for 6 years or 5 or 6 years, and then they jump to another firm, and then the other firm goes ahead and settles the case. So, anyways, fee dispute case, kind of interesting. Don't typically encounter these with these mandamus things, but that's why I figured I'd bring it to your folks' attention. I'll put the link in the description below. Again, I already mentioned, get an attorney involved. Don't do this stuff alone. It's way too complicated. Ask your friends, neighbors, coworkers, family, etc. Say, who do you guys recommend? Talk to that attorney. Talk to many different attorneys if you need to. Find the one you like, and then hire them to get involved with your case and claim. And that's that. So appreciate you listening to this video. As always, stay safe. Thank you. From Malik and Malik.